So today we have with us Advocate C. Saifullah, who is a who's a practicing advocate at the Madras High Court and also a very important legal scholar in the Chennai community. So he has been very active in the legal profession, and also he's a guest lecturer in multiple occasions, particularly in Government Law College Chennai, uh, School of Excellence in Law, and SRM Law School. So it's a really proud moment for us to invite and to have Advocate C. Saifullah with us to discuss on this very important and very nuanced topic. I would say it's also need of the hour. At the same time, it's a very complex topic for common people to understand. So we thought that we should organize a more of a socio-legal discussion. And we have with us Advocate C. Saifullah. So without wasting much time, so we would like to move on to the to the discussion. Right. Yeah. So, and presenting yourself using
Bismillahirrahmanirrahim. Alhamdulillah Rabbil Alameen. Uh, Assalamu alaikum wa rahmatullahi wa barakatuh. I invite everyone for this lecture touching the topic Waqf Amendment Act 2025. And before going into the lecture, uh, I would suggest that the the listeners, the participants who have joined this lecture, kindly maintain silence and be focused on the lecture and don't discuss anything. There will be a time is given for the participant for the Q&A and deliberation session after completion of the lecture. So kindly listen patiently the lecture and be focused. And secondly, some of you have some notions about the Waqf law, some preconceived notions or some political narratives which has been given for in this Amendment Act 2025. So keep set aside apart and have a clear mind. And after going through this lecture, then you can make a self analysis and assessment about the proposed amendment of Waqf Act 2025. Okay. Now I'll start with the introduction of this Act 2025. This Act 2025 was introduced as an Waqf Amendment Bill 2024 on 8th August 2024 in the Lok Sabha. And after the moving of this bill, there was a public furor across the Muslim and as well as the non-Muslim community across the country. And therefore, the bill was referred to the Joint Committee on 9th August 2024. Now, the joint committee was comprised of, you'll see the composition of the joint committee, which took the Herculean task of reviewing the proposed amendment, the bill. The chairperson was all you know, Jagadambika Paul, and the members of the joint committee from the Lok Sabha, there were 21 members, and from the Rajya Sabha, there were 10 members. Of course, one member who has subsequently resigned in the month of January 2025. Suppose there was only 9. And the secretariat also participated in the joint committee, consists of 18 uh, staff of the secretariat. And from the Ministry of Minority Affairs, there were 3 members, secretary and the joint secretary and the director. And from the Ministry of Law and Justice, there were 4 officials who participated in the joint committee. They were secretary and additional secretaries. Having said this, after the deliberations of the bill 2024, the committee submitted its report on 29th January 2025. The committee report, it consists of 914 pages. And after the submission of the committee report, the the act was passed by the parliament, by both the Lok Sabha and Rajya Sabha, and it went to the assent for the President of India, and the President gave the assent on 5th April 2025. And finally, the Act came into force as Waqf Amendment Act 2025 on 8th April 2025. Now, this is what the introduction of the bill and the coming of the Act coming into force on 8th April 2025. Before going into the or decoding the Amendment Act 2025 and its most controversial provisions and some provisions which are welcoming, one should understand the the origin of the Waqf doctrine. For that, I will start with an understanding of Islamic jurisprudence in very simple manner. The Islamic jurisprudence, the sources of Islamic jurisprudence is very different, very unique. Any law which is to be declared as a valid Sharia, it should emanate from four sources. Number one is the Quran. Number two is the Sunnah or the Hadith of the Prophet Muhammad Sallallahu Alaihi Wasallam. The Sunnah again consists of three categories: the sayings of the Prophet, the actions of the Prophet, and the approvals of the Prophet. The third source of Islamic jurisprudence is Al-Qiyas, sorry, it's Al-Ijma. Al-Ijma means the consensus of the companions of the Prophet. During the time of the Prophet, there were several companions associated with Prophet Muhammad Sallallahu Alaihi Wasallam, where so many things have been discussed amongst them, and most those things touching to the Sharia has been discussed, and it was approved by the Prophet. And this is the third source of Islamic jurisprudence, that is Ijma, and the fourth one is Al-Qiyas. Al-Qiyas is the logical reasoning. So if a law has to be derived, one has to first start from the Quran and followed by the Sunnah and followed by the Ijma. If all the three categories a person cannot find in a valid Islamic law, then the person can employ the chaos, the logical reasoning of that particular situation or circumstances with the approval of the Quran and Sunnah, then it becomes a valid Sharia law and the Sharia compliance. Having said this, these are the sources of Islamic jurisprudence. Now we will move to the concept of Waqf. What is Waqf? What is the definition of Waqf? See, the Waqf is an Arabic word. It means that linguistically it means to restrain or to stop something. This is its meaning. In the parameter of a property, what Waqf enables is it stops the property from devolving, or it stops the property from continuing or transferring its title to someone. So it ceases the property. Therefore, it implies to restore the ownership of something permanently and not to evolve or not to transfer. So this is the purport of the word, Arabic word waqf means. So therefore, once a property has been designated as an waqf, then it cannot be claimed by any individual, and it is permanently dedicated to public welfare and charitable and religious purposes. So it means the waqf is as the doctrine of perpetuity. So who are the stakeholders in a Waqf property? There are the first one is the Waqif, who donates the Waqf or who creates the Waqf is called the Waqif, and the Waqif, there is a purpose of behind the Waqf is for religious, charitable, and pious purposes, and according to the Islamic law. And once the property has been donated, the most important and very unique feature under Islamic jurisprudence or the Waqf jurisprudence is the ownership and the title vests with Allah subhanahu wa ta'ala till the day of judgment. So till the Qiyamah, the title and the ownership of the property vests with Allah subhanahu wa ta'ala. And of course, there are a list of beneficiaries of the work properties that we will see in due course of in this lecture. Now, where this Waqf institution came from? The first Waqf endowment it can be traced directly to the mouth of the Prophet Muhammad Sallallahu Alaihi Wasallam, an incident which is traditionally, authoritatively has been confirmed in Sahih Bukhari. That is uh, Umar bin Al-Khattab radiallahu anhu, the second caliph of Islamic Empire. He got a piece of land from Khyber. When he saw the land, he was in the interest to use the land, but he went to the Prophet Muhammad Sallallahu Alaihi Wasallam for an advice how to use this land which he got from the Khyber. The Prophet, the words of the Prophet is very important and it's very unique. The Prophet Sallallahu Alaihi Wasallam said that tie up the property and devote the usufruct to the welfare of the human beings, and it is not to be sold or made the subject of gift or inheritance. So therefore, the first most precedent, the endowment of work starts from the Khyber as per the Islamic tradition. Now, what is the institution of work? What are the significance of the institution of the work? You should understand. Work institution plays a very central position in Islamic civilizations. So generally a Waqf institution is associated with the institution like social, political and legal and religious economic dimension with the various social classes with the diverse and different context of their needs. Therefore, a Waqf deed, which is termed as Waqfiyah, is very crucial for the advancement of the socio-economic and political status of the Muslims for which it has been dedicated. It was said by a scholar, an Islamic renowned scholar, the Waqfiyah, that is the Waqf Nama, the deed of the Waqif, it is like a cut precious gemstone. So wherever you see through the precious stone, the dimensions will be so diversified that most of the sects groups will benefit out of the charitable purpose for which the endorsement has been made. Now, as already said, we'll see what are the stakeholders and the elements of a Waqf institution. The first and foremost is a Waqf institution will consist of founder, and this founder he dedicates movable or immovable property in perpetuity, and the ownership, once it has been endowed, the ownership vests with Allah subhanahu wa ta'ala till the day. Therefore, the sources of revenue or commonly for a work endowment is the rent from the buildings. It may be commercial or it may be residential, and the waste from the agricultural lands. And these are the revenue which generates. And who are the beneficiaries? The beneficiaries are the mosque, dargah, and madrasas, and hospitals, and educational institutions, and the poor and needy, and sometimes the family members of the Waqif also, or any other for those recipient which the founder, the Waqif of the Waqf endowment, he especially mentioned in his Waqf deed. Now here, one of the most important characteristic feature of any Waqf endowment is the Waqf Nama, the founder of the
Hello,
Waqf issued.
sir. Speech வரல, sound வரல.
Yes, please, yes, please. The sound, check the sound. Are you audible? Now I am audible, sir.
Yes, sir. Yes, sir.
Okay, fine. It's okay. The most important characteristic feature of a Waqf endowment is the founder, that is the Waqif, he has to specifically mention that this Waqf, since that endowment, the property, the more property which has been endowed, it should have a consistent generation of revenue. It should regenerate the revenue in perpetuity. It is not only the title or the ownership has been vested with the Almighty Allah subhanahu wa ta'ala, but it should be taken into care that the Waqf environment should consistently should regenerate revenue. Otherwise, the object of the Waqf deed, the object of the founder, that would be defeated. So having said this, now we'll go to the definition. The definition, which is something which is very controversial in the Amendment Act 2035. So that we'll go see in later. What are the controversial aspects? Yes, any issues there? Please don't talk, dear participants. Please be silent. Anything you put in the comment box, so the team will address your issue. Now, please listen carefully to the definition of the Waqf. Waqf means the permanent dedication by a person professing Islam of any movable or immovable property for any purpose recognized by the Muslim law as pious, religious, or charitable. This is the general definition. I once again reiterate, it is only short definition only. Waqf means the permanent dedication by a person professing Islam of any movable or immovable property for any purpose recognized by the Muslim law as pious or religious or charitable. Now, this definition, it is a secular definition, but even though it has some purport of Islamic doctrine, in the Waqf Act 1954, Section 3L, just please listen in detail in the due course of lecture. We will see what is Act 1954, 1995, and so forth. In the under Section 3L of the Waqf Act 1954, this definition is retained, and subsequently Section in Waqf Act 1995, Section 3 subclause or the same definition is retained. Here there is an Amendment Act 2013 to the 1995 Parent Act. Now, one thing I hope that the participant would have aware that this Waqf Amendment Act 2025 has made changes and modification to the Parent Act 1995. This you have to keep in the mind the entire lecture. This is the only Amendment Act 2025. This is not the new Waqf Act 2025. The Parent Act is Waqf Act 1995. In the 1995, there is an amendment in the year 2013 where they just changed one letter. Earlier it was WAKF, Waqf, WAKF. They removed the K and they inserted Q, Q for Queen, Q Waqf, and therefore this definition was consistently has been carried out in all these two legislations, that is 1954 Act and 1995 Act. But there is a radical departure of this definition under the Amendment Act 2024 under Section 3R, which we will see in due course in the lecture. Now we will go to the India. Now, what are the categories of the works which are recognized in our country, in India? What kind of works are recognized? There are three categories of works are recognized in India. That is, one is the work by user. Work by user means where the endowed work has been used continuously and where there is no any objection by the endower, that is the Waqif, and there is a continuous practice of in possession, and the Waqf endowed has been given, all the benefits have been given to the masses without any documentation. So a Waqf which has been continuously used, for example, I would say Dargah. Most of the dargahs are comes under this category, work by user. For several centuries they have been as dargah, or several centuries or some graveyards, Kabristan, they have been Kabristan. So, having a continuous usage of a particular work endowment without any interference from the owner or the founder or whoever claims that particular work property, then it is called work by user. And this is also some controversial under Amendment 2025 that we will see later. Then next category is the Mashrutul Kidamat. Mashrutul Kidamat means a public waqf. This is the general waqf. This waqf is the public, and this waqf endowment is devoted for the benefit of the general Muslim community, and this is a public waqf, and it's very simple. And the third category is waqf al-awlad, and this waqful awlad means, and it is a unique feature of Islamic waqf jurisprudence, that compared to other the endowments. That is, it is the Waqif, the founder of the Waqf, this kind of Waqf, he donates the endowment to his own family members and descendants. So Waqf means the endowment, al means the aulad means the descendants, the Waqf of the descendants. So all the benefits and which are the fruits of the endowed Waqf will be go to the highest successive descendants of the founder of the Waqf endowment, the Waqif. Now, having said the three categories, these three categories of the works in our country, and the first one, work by user, and the third one, that is Waqf al Aulad, the work of the descendants, they are subject to controversy in this, the Amendment Act 2025, which we'll see and discuss in later. Now, we'll come to the development of Muslim works in India. Where does the first work you can find in India? Here, there is an earlier description of work found in a rare book. This book titled Inshahi Mahru. Inshahi Mahru was a book which is written by Ainul Mulk of Multani. Ainul Mulk Multani, he wrote this book, Inshahi Mahru. In this, he mentions three categories of works has been made as an endowment at that relevant point of time. That is, one category he says that the works which has been created by Saladin Mazi. Works created by Saladin Mazi means those works endowment which have been created by the kings. Second category was created by Mashek and Umara. Second category is Mashek and Umara. This means those category of works which has been endowed by the men of wisdom, science, and the noble persons, the scholars, and these particular category that these people are making about adornment. And the third one is Sultan Muhazzin, one of the Gori Sultan. There is a reference that Gori Sultan in the year during the year 1185 to 1195 AD, the Gori Sultan, during this period, 1185 and 95 AD, he has dedicated two villages in the favor of Jumma Masjid of Multan, and it handed over to administration to one Sheikhul Islam. So these are the three categories of the earlier work found in an authoritative book called Inshahi Meru. Then we will follow after the establishment of the Delhi Sultan in the year 1206 AD. Many more works have been created during the Muslim rule in India. The large scale of constructions of public places like the mosque, tombs, and madarsa, Kabristan graveyards were all rampant. They have been endowed in very vast scale. And during the reign of the Akbar, the Mughal emperor, it is reported that he had made a generous grant in favor of his ancestors belonging to family of famous for his religious learning. So he named it as a Farhangi Mahal at Lucknow, and the later Mughal emperor of the grants, and he has did some grants to the madrasa also. In 1631 AD, Shah Jahan, what he did is he constructed a mosque titled Moti Masjid and he endowed as a waqf, and 30 villages and a pargana. Pargana means a group of villages or a district comprises of group of villages. This is what the Shah Jahan emperor, he endowed 30 villages, constructed the Moti Masjid. The most important feature of is this endowment is the 30 villages in Pargana, they were yielding the revenue of the work endowment of rupees 1 lakh rupees per year. See, can you just imagine the voluminous of the amount, 1 lakh rupees during 16th century. It was in the work revenue. And this was also recognized on all the in this Parwana. There's a Parwana is a work endowment deed where the Shah Jahan's the religious pious and charitable purpose for the Muslims has been mentioned. Having done this, then we go to the period of Sultan and Mughals. And during the period of Sultan and Mughals, they don't have an exclusive Waqf administration system. They did not create a separate institution to manage and administer the Waqf. But what the structure at that time of the Sultan Mughals to manage, administer, and the Waqf was they appointed a chief ecclesiastical officer. He is named termed as Sadar us Sudur, Ethiadia Sadar US, Sadar us Sudur, Sudur. He is Sadar us Sudur of Empire. He is the most highest rank of a designated chief ecclesiastical officer to administer and to supervise the endowed Waqf during the reign of the Sultan and Mughals. And there is a chief link between the king and the people. And the more important feature of this particular designated officer is about the qualification. If one has to appoint as Sadaru Sudu, the chief or designated officer to supervise the work for the endowed by the Mughal during the reign of Mughals, his qualification, see, it's very worth to mention his qualification. The qualification of the for the post of the Sadur Sudur, according to the Hidayat ul Rawaid, this is a book. In this book, they have mentioned the qualification. The Hidayat ul Rawaid, authored by Hidayatullah Bihari, where he mentions the characteristic which this person has to possess in order to appoint as a the Sadar Sudur designate. Number one, he should have a sound knowledge of Sharia. Number two, pity. Number three, honesty. Number four, scholarship. And number five is good family lineage or good family background. Now, this is the in the structure, managing and administration of the work. He is the topmost officer. He is succeeded by under him at the level of Praganas, which I have already mentioned, the group of villages Praganas. The Kasi looked after the Waqf administration, and he played a dual role. One role is he took after the administration of the Waqf property, and he also uh, has been acted as a district Qazi to try and dispose the civil and criminal case and some canon law cases. And he was also designated as a judicial officer. And at the village level, the Waqf accounts were maintained by the mullah. And again, come to the down, and ultimately the Mutawali, who is responsible to look after the work administration, as still it continues today. And the mullah has been entrusted with the functioning to maintain the Waqf account. This is what the structure, what to say that the organizational setup of to manage and administer the Waqf property during the reign of the Sultan and Mughals. Having said this, now we will come into the most important period of the Indian history is the advent of the East India Company. What was the work stages of the work endowment and administration of their condition in the when the East India Company came to India? Now, here, when the East India Company they came to India and started doing their operations, some British officers were appointed by them to look after the affairs of the Indians. But these British officers, what they will do is, whenever any issue is reported to him, he will send a letter to the directors of the East India Company who were at that time at England, and they used to give advice. Okay, this is the problem. You deal with this proposition like that. There were no any act or such thing or any legislation. The first and the famous regulation, the statute form of regulation came is a Royal Firman Regulation of 1772. This is the first regulation of the East India Company where touching the issues of the Muslims and Hindus, they promulgated, that is the regulation of 1772 Royal Firman. According to section 27 of this 1772 is very crucial. Section 27 of this regulation of 1772, it said that the Hindus and Muslims shall be governed by the Muslims shall be governed by the Quran and the Hindus shall be governed by the Shastras. Therefore, there is no business of the British officer to interfere into their respective scriptures or custom and usage and whatever practice they follow. This was there. So up to 1810, there was no absolute any interference of East India Company into the affairs of the Waqf environment or the Muslims. Interference began at the promulgation of the Regulation 19 of 1810. This is very crucial. 19 promulgation of 19 of 1810 of the Bengal Code. What happened is the East India it was learned by the East India Company that most of the considerable endowments across the country, which have been transferred the land for the benefit and purpose for the mosque and temple, has not produced of such benefits to the contrary to the intention of the donor. There were some malpractices and mismanagement and corruption were been happening across the country of these environments. So as the result, the Eastern Company felt that regulation of Bengal Code 19 or 1810 and the regulation of 6 of Madras 1817, what they did is they issued the promulgation of a general superintendence which was vested with the Board of Revenue and the Board of Commissioner. So all the endowments which will be benefit for the temple, masjid, they all come within the ambit of the control of the general superintendence of the revenue commissioner. And this was the state in the year 1810 and the outcome of these two regulations. Now, after this, we will move on to an important, the first act which came in the British period was Religious Endowment Act 1863. This is the very most important watershed endowment act touching the Waqf endowments, which relates to both the Muslims and the Hindus. What happened is, in this Endowment Act 1863, the act brought a fundamental change in the policy of the government responsibility for the protection and preservation of the Waqf properties. Therefore, what they did is the government diversed itself from all the matters concerning the management of the Waqf properties. As a result, what happened, the outcome of the Act 1863, the possession which had been seized by the Board of Commissioners of Revenue, they transferred the possession to the respective Muslims Waqf and the Hindus Waqfs. So there was a reversal of the transfer. This is what 1863. Now we will move on to another one significant act during the period of the British was Indian High Courts Act 1861. What is the relevance? The relevance is this act is 1861 High Court Act is very crucial. If one is not having an understanding of the operation of the High Court Act 1861 and what has happened subsequent to the 1861, that individual cannot appreciate the recent Amendment Act of Act 2025. It's very crucial. What High Court Act 1861? See, one thing happened in 1861 is the High Courts are established under the Queen Victoria in Calcutta, Madras, and Bombay in 1862. Now, here one thing happened. The first mistake that British did in India is they termed Islamic jurisprudence as a Mohammedan law. In the book of the commentary of Mullah in Islamic law, that is the 16th edition, the commentary Mullah on Islamic law, the preface was given by the eminent Islamic jurist Justice Hidayatullah. He was the Chief Justice of Supreme Court of India at that relevant point of time. In his preface, he criticized this act of British terming the Islamic law as a Muhammadan law because it is Prophet Muhammad never claimed that the Sharia is belong to him. Contrary, the Sharia is the lawgiver of the Sharia is Allah subhanahu wa ta'ala. But however, the British made this misconceived and misconstrued the definition as Muhammadan law. I don't know what happened in the 1861 Act. It stipulates that any judge to be appointed to the High Court, this is very important. Any judge and judge designate to be appointed as a judge of a High Court under 1861 Act, he has to be a barrister for minimum 5 years. Barrister means what? He should be practiced in England for 5 years. This is the minimum qualification to become a High Court judge under the 1861 Act. Now, what is the consequences at that point of time? The British lawyers and the British judges, they they fusioned the Islamic jurisprudence with the thought process of the British thought process. So they understood and construed the Sharia implications with the English mind. So what they formulated is Anglo-Muhammadan jurisprudence. Anglo-Muhammadan jurisprudence was that product. Unfortunately, the Anglo-Muhammadan jurisprudence itself a conflict with direct to the Islamic Sharia. So what with this main setup of Anglo-Muhammadan jurisprudence, they started dealing with the cases whichever come to them. Now, one important case, a leading interesting case which came to them in the year 1885, that is Queen Empress versus Ramzan. The, this case is very leading case, and this case is it was dated on 22nd August 1884. They gave the judgment, and I will also give the citation of this case, Queen Empress versus Ramzan, 1885 ILR Allahabad at page 461. 1885 ILR Allahabad at the page 461. One can find this case, and this case is available on the net. No issues. Now, this is the interesting facts. Here, what happened? The facts of the case is the on 22nd August 1884. The judgment was delivered on 7th March 1885. The incident occurred on 22nd August 1884. Some group of Muslims, they went to offer namaz in the masjid at Banaras. While they were offering namaz, then the imam, he concluded the first recited Surah Al-Fatiha, and he said, all the namazis, they said Amin. In one set, the majority of them, except the three people, the three Muslims, all they murmured Amin inside their mouth only. They did not recite it loudly, the Amin. But there was the Ramzan and his associate, they said it loudly. Now, what is the complaint was, these all other namazis, they follow the Hanafi school of law. They have the tradition of saying the Amin very slowly. But the Ramzan and his associates, they belong to the Wahhabi sect. Therefore, they recited loudly. Consequentially, which is an interference of nuisance to them and attracts an offense under section 296 of IPC at the time. So therefore, they gave complaint against the Ramzan and other the namazis, and the magistrate, he went through the complaint and he convicted Ramzan. In fact, two offences under section 296, creating an internal disturbance and nuisance in the masjid by shouting Amin, attracted the offence. Then Ramzan was convicted. Now what happened? Ramzan went to the appeal. He went on appeal to the High Court Division Bench, where the Division Bench of the High Court, Allahabad High Court, found that there is some religious intricacies or religious law has to be interpreted, because one school murmurs Amin inside the mouth and another school says that no, you have to say loudly Amin. See what kind of controversy. Now, therefore, they refer this case to a larger bench. Larger bench means what? 5 judges bench. See the ramifications of the issue, which started in the local masjid by just offering a namaz of just 2 minutes or 3 minutes. Now, what happened? Now, what is the composition of the judge? Composition of the judges are very, very important. All the four judges are British barristers. One judge is an eminent, a classical judge, Justice Syed Mahmood, who himself a barrister, is none other than the son of a legendary social reformer, Sir Syed Ahmad Khan, who is the founder of the legal Muslim Institute. He is his son. Justice Syed Mahmood is his son, and he is also in the bench. Now, what was the verdict? After going through the elaborate arguments, the verdict was 4 is to 1. That means the majority, 4 judges, they said, okay, fine, something has happened, no issues. You say one school of jurisprudence, they say another school of jurisprudence. So we will do one thing. We will remit the matter for retrial to the magistrate. Again, the magistrate has to conduct the trial, which the parties are at liberty to adduce their evidence according to the religious scriptures. This was the 4 judges majority view, but dissenting view, which is the most landmark and proposition settled by law, that by Justice Mahmood said, no, no. See, here you have to look into the Islamic practice. When there is here a legal principle is there, so listen carefully. When there is a legal statute which impinges or which affects a religious practices of a group or a sect, then that particular legal statute or provisions of the act has to be has to be deliberated, has to be examined under what the religious text says. It is not that you blindfoldedly take the statute and you provide the law. That has to be subject to the scrutiny of the religious jurisprudence. This is what Syed Mahmood did. Said he analyzed various fixed school of jurisprudence, and what he found is he said that the Hanafi school of law, there is a opinion of the jurist where when the Imam concludes Salat in Surah Al-Fatiha, it is also permissible to say it loudly. Taking the cue from this Hanafi fiqh jurisprudence, Justice Syed Mahmood, he dissented and he said, sorry, I cannot able to concur with the majority view. Therefore, there is no any offense as made out under section 296 of IPC, because the religious jurisprudence is very clear in this matter. So that is how that case is came to an end. But however, the proposition of legal principle which Justice Syed Mahmood settled in the year of 1885, it's of eminence importance in future hearing of the Supreme Court of the SLP challenging the Amendment Act 2025. Having said this, now see the consequences of the Anglo-Muhammadan jurisprudence. Very dangerous proposition. The British judges were seeing all the disputes under the lens of the British men, and this was the bent. They were bent of the British men. This culminated the most important revolutionary, I would say, the most controversial judgment. That is, I will give you the title, Abul Fata Muhammad Ishaaq. Abul Fata Muhammad Ishaaq versus Rusomi Dur Chowdhury. Abdul Fatah Muhammad Ishaq versus Ruzomoy Dur Chowdhury, reported in 1894, page 22, Indian Appeals to the Privy Council, page 76. 1894, volume 22, Indian Appeals, page 1976. This is a landmark case. And what has happened in this case, Abdul Fatah Muhammad Ishaq? Now, since the British judges, barristers were bent upon the English mind, the thought process, everything was going on only on the English law. One case came in here, touching the doctrine of Waqf al-Awlad. That is the one of the category of the Waqf al-Awlad, which I reiterate that Waqf al-Awlad means where the Waqif, where the donor of the Waqf property, he donates the Waqf endowment to his children and is followed by his subsequent grandchildren, and it follows through the entire descendants till the line of hierarchy ends, and it reverts back to the any other social purpose or religious and charitable pious object. Now, in this case, what happened that in the Waqf al-Awlad, since the English law was being well rooted in the doctrine of trust, trust is different from the Waqf. So they said that, see, how do you give a charitable thing to your own generation? It is conflict of the doctrine of trust. Once you going to give for charity something, of course, some portion you may retain, but you can't completely devolve the entire property, either removal or movable for the welfare of your generation. That means it doesn't qualify the characters of a valid charity. Therefore, those judges they said we can't recognize the doctrine of Waqf al Awlad. Therefore, they gave this a sensational, the most controversial judgment. What happened? The consequence of this judgment paralyzed the power of a Muslim to make a settlement in favor of his family, children, and the descendants, which has been duly recognized by the Islamic Waqf jurisprudence of several centuries. And there was a furore. There was a furore, and by the Muslim community against this judgment. Then what happened? In order to undo the mistake which did by the Privy Council, this act came into force, the Validating Act 1913. The Musalman Waqf Validating Act 1913, it what it did was it overcome the hardships which created by the Abdul Fatah case. What they did is they invalidated the judgment of the Privy Council and they said Waqful Awlad is allowed and it is permissible. But the what is the difficulty was there in this Act 1913? When this Act 1913 was interpreted before the courts, the English judges they felt that yes, the Act has invalidated our judgment, but it is not a retrospective effect. Yes, okay, fine. Akal Aulad is okay, it has been restored. This doctrine is restored, but the act doesn't stipulate any retrospective effect of operation. Therefore, it is only prospective. So they did not encourage the litigation and further, which necessitated and compelled the British to enact the Musalman Waqf Validating Act 1930. The Musalman Waqf Act Validating Act 1913. Now, this act cleared the embargo which has been created by the earlier Act 1913 and 1930 Act gave the retrospective effect. It gave the retrospective effect. Now we will go to the subsequent to this, then another act came, that is Musalman Waqf Act 1923, and this act is also very significant. It came before 1930, the Musalman Waqf Act 1923. What was the object and purpose of this Act 1923 was the mutawalli of every waqf except waqful awlad, he has demanded to claim to furnish the court of district judge of the statement giving information regarding the description of the property, gross annual income, gross income accumulated during the previous 5 years. So the Mutawalli, this 1923 Act gave the duty of the Mutawalli to submit the audit and accounts of the income and all those things before the district judge for the previous 5 years. Now, one practical difficulty came while implementing this act is already the civil courts were burdened with the litigation war. In additional to these Mutawallis coming and giving some audit reports and to scrutinize that, it was a very uh, cumbersome and it was an Herculean task for the courts. Therefore, this particular object of the act doesn't went well, and therefore this act ultimately 1923 it fall off short of time, and because there was no any constructive implementation has been carried out because of the difficulty. Now we will move on to the one of the watershed act which comes in India. This is post. This is the in the from the state perspective. That is the Bengal Waqf Act 1934. Bengal Waqf Act 1934. It is considered as a pioneer of all the Waqf legislation in this country because it is the first Bengal Act, Waqf Act 1934, introduced the formation of the Waqf board and appointment of Waqf commissioner. Appointment of Waqf commissioner, and it had 93 sections, and it was divided into 13 chapters. And this is what about the state of Bengal Waqf Act of 1934. And if for academic interest, someone can go through this act. It still is there. And now we come to the Act of 1954. This is something which is the first central legislation of the government touching the Waqf properties across the country. Waqf Act 1954. And almost this is the central legislation. Almost it covered, it was governed, and it covered all the length and breadth of the entire administration of the works across the country. But this particular act, it was not to the satisfactory, and the expected administration management of the works across the country while the implementation of the 1954 Act, there was many problems were raised from across the community on the misadministration of the works, mismanagement of the works. So therefore, the government constituted, it came to the attention of the central government about the mismanagement, and the parliamentary committee known as Waqf Inquiry Committee was constituted in the year 1969. And Mr. Ghulam Rasool as the secretary for the purpose of the working of act, and the committee again deliberated the pros and cons and the active implementation of the Act 1954. And finally, this committee submitted the interim report in the year 1973. And the government, the Ministry of Minority, and all the stakeholders, they culminated this committee report to introduce an act called Waqf Amendment Act 1984. So Waqf Amendment Act 1984 is an amendment which is proposed to be made in the Waqf Act 1954 based on the report committed by Ghulam Rasool Committee. Now everyone agreed upon to the 1984 Amendment Act 1984. Then what happened? Even the president also gave his assent on 10th October 1984. But what happened? The post assent of the president of 19 in the October 1984, some stakeholders felt that it will create problems in the states. The implementation of the 1984 Amendment Act will create problems across the state. Therefore, it is not feasible to introduce this law, and therefore, it never came into the official gazette of the central government. It went to into the graveyard. 1984 Amendment Act. It became the dead letter, and it's a dead letter only in the statute book. Now, this is what, but one thing is that one suggestion has been made in this report that we'll see in the later. After going this, we will now see the Parent Act 1995, Waqf Amendment Act, Waqf Act 1995. Look at them. Thank you. Yes. This Waqf Amendment Act 1995, I would say that it is a well deliberated and carefully drafted legislation. It 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 it, it encapsulates all the framework of the Waqf Islamic jurisprudence, taking into account of all the issues which revolves the Waqf administration and management across the country. It's endowed as the Islamic Waqf, and this law came into force. And this is one of the well drafted legislation, the Waqf Act 1995. That is the Parent Act still now. Now here we will see some important provisions of this Act 1995, which are noble provision. I would say that it would benefit the Muslim Waqf endowment immensely, which has benefited. That is, we will take the powers of the central government. See, powers of the central government in the Waqf Act, sections are running from 9, 12, 96, 102 and 106 are the, these gives the vast powers to the central government. One significant section under the Waqf Act is section 96. Section 96 of the Parent Act, you will see, which gives a vast power to the central government. At that relevant point of time of 1995 itself, it says that power of central government to regulate secular activities of works. Secular activities of works to lay down the for the purpose of regulating the secular activities of work, the central government shall have the following powers and functions to lay down general principles and policies of work administration in so far as they relate to the secular activities of the work. And what are the secular activities? The explanation, see, that is very important. For the purpose of this section 96, central government shall make the following powers touching secular activities shall include social, economic, educational, and other welfare activities. See, what are the secular activities? Social, economic, educational, and other welfare activities. This means what? This is actually goes directly to the Waqf endowment. If a Waqif, the donor of the Waqf endowment, has written that in this Waqf endowment, the Muslims has to construct, the Mutawalli has to see that hospitals are constructed. See, then some colleges are being constructed, some educational institutions are being constructed for the welfare of the Muslims, and and the Mutawalli, in pursuant to the intention of the founder, he proposes a medical college, a medical institution, which has to be constructed to the benefit of the Muslim community in the so-called donated work endowment. Then, obviously, as per Section 96, the central government will be free. What powers you are agitating now in 2025 Amendment Act? See, 1996 Waqf Act, Parent Act itself, this section 96 is there. Where before, earlier itself was powers has been vested with the central government. This is 96 is very crucial. Now we'll go to the state government, and there are many other powers, no need to say. And state government, very crucial. The state government also has been conferred with vast powers under the Parent Act 1995. One is Section 32. Section 32 of the Parent Act 1995 gives a sweeping power to the work boards. They are crying that work boards have been maybe to some extent, but 1995 Act Section 32, there is a sweeping proviso. It says that the state work board, subject to any rules that may be made under this act, the general superintendents of the works, the general superintendents of the works in the state shall vest in the board established by the state, and it shall duty of the board to exercise its powers under this act to ensure that works under its superintendence are properly maintained, controlled, and administered, and the income thereof is duly applied to the objects on for the purpose of which such works are created or intended. So therefore, the power of the general superintendent and to administer and manage all the works across the state belt. The sweeping power is conferred under Section 32 on the state board by the Parent Act 1995. Then again another power will come. That is the alienation power section, which is very controversial debate. That is under the Amendment Act 2025, the encroachment and the alienation. Section 51 gives that any alienation of work property, that is, alienation of work property means those work property which are notified in the official gazette, which has been designated as a Waqf property, if there is any alienation without the sanction of the board, without the sanction approval of the board, if there is per se any alienation, then to such extent it is deemed to be void. See the power which they have given to the board. In one stroke, void means in legal principle it is non-est, it is illegal, and it is nothing there, nothing deliberation can be given after that. So this is the section 51, and another power will go to the section 99. What section 99 says? Section 99 says it also gives a sweeping power to the Waqf board. This is power to supersede the board. This power is given to the state government. State government has given an extraordinary power under section 99 to power to supersede board. That is, this power is if the state government is of the opinion that a particular Waqf board is not functioning properly, where the properties are mismanagement or some corruption or something which is not has been checked and scrutinized by the board, and inspections which are not carried out periodically, and where the directions issued by, here the phrase is very important, where the direction issued by the central government under section 96 or the state government under section 97, or if the state government is satisfied on consideration of any report submitted after an investigation, after inspection, the board continues is likely to be injurious to the interest of the works of the in the state, then the state government by notification in the official gazette supersede the board for a period not exceeding 6 months. Now what is there is some breathing space is given to the board, because the now what happened is when the state government seizes the board and it takes the supersession, then the board suffocates. But they are only given the time for only 6 months of suffocating. After 6 months, they will release the clutches of the state arm so that the state work board can again operate independently. But there is a rider. The rider is this 6 months time will be extended on the expiration of the period of suppression specified in the notification issued under the subsection. The state government may extend the period of supervision for such further period as it may consider necessary. So it is not guaranteed that after 6 months the board will retain its autonomy. In it's the opinion of the state government, if the suppression has to be, if the period of suppression will be extended, it may be extended for the such period which may consider. That means what? It gives the discretionary power of the state government to extend for another 6 months or another extend for another 1 year. You know, this is the power of the state government under section 99. And having said this, now we will go into the most controversial, not controversial, but it is, I would say that it's in a very good academic interest subject, the Permanent Act 2025. Before going into the Permanent Act 2025, we will take a pause of 10 minutes, 5 to 10 minutes break. Then we will resume this lecture. The Permanent Act 2025. Then the Bill Amendment Bill 2024 was proposed in the Lok Sabha by the government. The government relied upon the sources of the recommendation of the Sachar Committee report 2006. And the government also relied upon some incidents of claiming ownership of properties across the country, and the central government has received some complaints about the mismanagement and the occupation or the unauthorized occupation of the work. So taking into account of these complaints and incidents, as well as the recommendation of the Sachar committee report touching the improvisation of the administration and management of the work properties across the country. Therefore, the central government is proposing this amendment bill of 2024 of the Waqf. Now we will see what does the Sachar committee recommendation has dealt with the management and administration of the Waqf across in India. For example, for that we have to go through the Sachar committee report. What is Sachar committee? Sachar committee on 9th March 2005, the Prime Minister office it issued a notification for constitution of a high level committee for preparation of report. Now this is very crucial, touching the social, economic and educational status of the Muslim community of India. So this committee was constituted by the having the chairperson Justice Rajinder Sachar, and this committee, after going through vast deliberations, discussions, and traveling across the country, and it did an enormous field work across the states, touching all these parameters: social, economic, educational, well-being of the Muslims living across the country. And finally, Rajinder Sachar, he submitted a report before the government on 17th November 2006. Now, in this Sachar committee, there are different subjects which has been the commission has carried extensive research, extensive field analysis. Chapter 11 of the Sachar committee report is very crucial and directly touches the leveraging community initiatives, the case of Waqf. Now, in this, the committee, it says various aspects of the work properties and their conditions of the conditions at that relevant point of time, and everything is mentioned. Now, the one of the very important paragraph in this particular chapter is this is the Sachar committee findings. This is at the time of 2006. You should have in mind that whatever the Sachar committee says, that is in the relevant period is 2006 when it submitted the report to the government. 2006, at that relevant period of time, 4.9 lakh registered WAFs spread over the different states and union territory of India. The large concentration of the work properties is found in the West Bengal, followed by Uttar Pradesh, and other states are seizable number: Kerala, Karnataka, so on. The total area under the Waqf properties all over India is estimated at about 6 lakh acres. And the book value around is the book value of these 6 lakh acres of the property is rupees 6,000 crores. However, the market value of these properties will be higher and manifold. For instance, a recent estimate of the current value of the work property in Delhi, that is the recent estimate what during the year of 2005 to 2006, the recent estimate of the current value of the work properties in Delhi alone is in excess of rupees 6,000 crores. Further, the work properties are about half the century old. The current value can safely be estimated to be several times more than the market value of the work properties, and it can be put up. This is the Sachar committee report finding. The market value of the work properties can be put at, hold your breath, rupees 1.2 lakh crore rupees. What is the amount and what is the value of the net worth of the properties? Unimaginable. If these properties, it is more crucial, now the more crucial, if these properties are put to efficient and marketable use, they can generate at least a minimum return of 10%, which is about 12,000 crores per annum. This Sachar committee report is findings in the year of 2006. What would be the value of the year 2025? You can't put built in the Google search engine the value of 2025. It will run. Alhamdulillah. Now, wherever the work lands and another findings of the Sachar committee is wherever the work lands have been put to efficient use, they have generated an average return of about 20%. Therefore, that if some of these work properties situated in prime locations across the country are developed and put to commercial use, their market value and annual income will shoot up. Therefore, here the most clinching part, which comes which the government claims that the findings of the Sachar committee is the committee would, however, like to put a caveat here. The committee would, however, like to put a caveat here. The optimum utilization of work properties would require proper administrative backup by both the central and state governments, as well as the legislative support by way of crucial amendments to the Waqf Act. By the way of crucial amendments to the Waqf Act and some other pieces of existing legislation. So this is what the Sachar committee findings, followed by another most important thing which is mentioned in the Sachar committee report is the list of properties. This you can find at the page number 222 at chapter 11 of the Sachar committee report. It states that a list of properties which are gazetted as work properties, that is the designated work properties, notified work properties, but are currently under the unauthorized occupation of the governments and their agencies, submitted to the committee is presented. So therefore, the Sachar committee has collected the verifiable and an authoritative data touching to those unauthorized occupation by the government and its agencies in the work properties. Now the list, there's a list is given, a box is given. Some instances of unauthorized occupation of gazetted works of the government and their agencies reported to the committee by various state work boards during the period of 2005 and 2006. Number one is Delhi, 316 work properties, followed by other states that is not relevant. Now here, one crucial letter is there. This work for chapter 11 is appended with one most important letter which was written by Prime Minister Indira Gandhi at that point of time. This letter dated is crucial, March 26th March 1976. This letter is appended to the Sachar committee report. 26th March 1976, the late Prime Minister Indira Gandhi, she wrote to the letter to the Chief Minister. This is the Chief Minister of Delhi, where she stated that asking them to either vacate or pay to the work boards the market value of the work properties. Alternatively, the directive was to pay lease rent at market rents for the work properties encroached upon by the governments and their agencies. So, in this letter, the Prime Minister Indira Gandhi gives a direction to the state government to hand over the work properties which has been unauthorizedly occupied by the government and agencies, or else you pay the rent at the prevalent market value at that point. This letter, Mr. Shekhar Gupta, an eminent journalist who runs the print, he has his channel, the print channel, and he has done an episode touching the Amendment Act 2025, and it was uploaded on 4th April 2025 in his episode Clutter, where Mr. Shekhar Gupta also he discloses this particular Prime Minister Indira Gandhi letter in his YouTube channel, and it is available in the YouTube. You can go and check it. See the importance and the gravity of the letter. But nonetheless, This letter also became a dead letter, and nothing has happened subsequent to the letter which has been written by the Indira Gandhi. Now we will move on to the one of the case study. The Sachar committee report is mentioned some case study where most of the work properties are under turbulence across the country. One is it is found that trifurcation of Punjab Work Board. What is trifurcation? Till 2004, there was a combined work board for Punjab, Haryana, Himachal Pradesh, and Chandigarh. Subsequent to 2004, there was a bifurcation of states have been done. During this bifurcation of the state, now each state work board were constituted. Before that, the entire revenue of all the properties, work properties which were lying across these states were pooled together, and the revenue was given to the Muslim community for their welfare and development of educational institution, madrasa and mosque. But after this trifurcation, what happened? 11,000 work properties in Punjab gone into the exclusive administrative control of the Punjab State Work Board. But however, in Haryana, there were a huge a Mewat belt where the under this Mewat belt there were large number of Muslims or backward Muslims or very poor Muslims were living in the Haryana. They could not be able to realize the fruits of the Punjab Work Board, which was administering and managing the 11,000 acres of the property. Therefore, now the Sachar committee, what it is, by bringing up this case study, it suggests to the central government. This is very crucial. The committee analyzed the representation made to it in this record and studied the issue. It is the view of the central government may revert to the status quo ante and undo the trifurcation of the S-file Punjab Work Board. This is the one of the recommendation of the central committee to the central government to look into to the undoing the trifurcation. Another case study which is mentioned very interesting. There is one college in Meghalaya, Shillong Umshirpi College, which was established in 1994 by the Muslims in Meghalaya. 1994, they have established. The title of the college is Umshirpi College. Now, what is the case study is, adjacent to this college, there is a work property lying. Now, the Muslims who constructed this college, they requested the government of the Meghalaya to hand over the property to the college for the further expansion. But already a land acquisition proceedings has been initiated by the Meghalaya government under of this particular work property. And therefore, the Meghalaya government said that it can't accede, not give consent to these Muslim founders of this college. But however, nothing has been done. No construction or no infrastructural development that has been done to that particular acquired work property. In spite of the land acquisition, the lands were kept bare. And these founders of this college, the Muslims, they approached the concerned state work board and the Mutawali to give a consent and approval, and they gave a proposal to do this effect. And even the state work board was concerned, and it gave a consent to use that the adjacent work property for the development of the educational institution. But however, still now the state government of Meghalaya is reluctant to hand over this particular piece of property or property to the Muslim institution. So, what does the Sachar committee does is in this the Sachar committee recommends the central government. Now, it directly this recommendation is goes to the central government. The central government may consider taking up this matter with the Meghalaya government and asking the Meghalaya government to pass necessary order, withdrawing the acquisition proceedings in respect of the said property and allotting to it to the college which has been founded by the Muslims and for the benefit of the Muslims. We don't know what is the status of this. This is the happened in 2006. This is an academic interest. Another most important case study in this report is the case study of National Capital Territory of Delhi. See here what happened, the factual matrices. The government of India at the relevant point of time, 1911 and 1915. Between 1911 and 1915, the government of India at that time, it acquired vast properties. Vast properties were acquired for the development of government institutions and its agencies across the Delhi. And it's a land acquisition proceedings. Compensation were also been given. Some received the compensation. Those who have not received the compensation were deposited in the district court, and still the deposit is still lying. Now, where is the controversy? The controversy is there was a claim of the Delhi Waqf Board. Certain properties which is designated notified work properties have been acquired by the land acquisition. Therefore, those properties of numbering 123 properties that should be handed over to the Delhi State Waqf Board. This was the controversy, and again, there was some litigation pending before the court between the Delhi court and the government as the defendant, as the opposite party. And this went, and several committees were constituted between 1974 and 1984. There were four high-powered committees were examined. What was the to resolve the dispute between the government and the Waqf board, and ultimately the committee gave the report that 123 properties, work properties, it was clear that they could be classified as work properties, and recommended that these are the committees, the committee recommended and recommended that they may be transferred to the Delhi Work Board. The government of India approved the recommendation of the committee. This is very critical. The government of India approved the recommendation of the committee on 31st January 1984 and ordered the transfer of 123 properties to the Delhi High Court. What happened? In intervening period, one thing happened. A writ petition was filed before the Delhi High Court by one stakeholder. On 1st June 1984, the Delhi High Court ordered the status quo. And the status quo was that pending status quo. Again, and when the Union Government of India, when it filed the counter affidavit to the writ petition, in the reply, the Government of India said to the Delhi High Court that it said that only after thorough scrutiny of the notified work properties and verification at the site, it was decided to transfer it to the Delhi Work Board. Only such properties, there were some four categories, it is only small only. These four categories are entitled after the subject to the scrutiny of the title and the gazette notification that there are indeed deemed work properties, then they will be transferred to the Delhi Work Board. Those four categories are clearly waqf in nature. Number one. Number two, not required for public utilities. Number three, clearly separated from adjacent public buildings. Number four, the transfer of property to Delhi Waqf Board is for the effective management and in the public interest. Then this will be done. Now what happened? Since there is a pending writ petition is before the Delhi High Court lying. Now the two stakeholders, almost after deliberation and negotiation and conciliation, mediation, everything happened. They came together. Okay, fine, we will resolve this dispute once for all. But due to the interim stay, there was an interim stay on 6th June 1984. There was an interim stay. Before there was only status quo, and subsequently interim stay was given by the Delhi High Court on June 1984. This matter was pending still now, and several years nothing has been moved forward. Now, what is the value? What is the net worth of these 123 properties? This is in 2003. Sachar committee mentions these are all the findings of the Sachar committee. Nothing from my mouth. In 2003, the market value of these 123 properties was estimated about 3,000 crore by the petitioners at the relevant point of time. The property prices in Delhi have since doubled. Therefore, these properties could now be valued, could now be 2006, valued at rupees 6,000 crore. Due to the protracted litigation, their economic value could not be tapped. If the commercial potential is now exploited, it could generate enough resources to meet the needs of the Muslim community. So what the Sachar committee say finally, this is very crucial, very crucial, very important. The government India, this recommends, this is the recommendation of the Sachar committee. The government of India may consider instructing its law officer to take an active interest in the matter and have the long pending court matter disposed of at the earliest. This could be done by getting the legal support upgraded and imparting the overdue urgency to the finalization of this case. Full stop. We don't know what is the fate of the WP, and I don't know. Now, now another important recommendation which has not been considered. A recommendation has been considered by the government. Amongst others, inter alia, the recommendation one is very forthcoming in the Sachar committee. Appointment of Group A officers for works. There is a strong case to create a new cadre of officers to manage to manage the affairs of the state work boards and the state work council. It is estimated that up to 200 Group A officers are needed to service the work affairs across the India. Therefore, the recommendation of the Sachar committee says that the government may therefore consider a new cadre of officers to be recruited by the UPS so that they can deal with the specific affairs of the work efficiently. Such officers should have the knowledge of Islamic law and Urdu, as most of the documents related to works are in that language. This is about the Group A officers, 200 officers. They are to be recruited by the UPC under separate category to not to administer the affairs of the works. We don't know what happened. Now we will come to the most another important influential economic and financial impact on the development of work properties. That is to set up a national and state work development corporation. Such a committee report recommends a national work development corporation may be constituted by the central government with a revolving corpus fund of rupees 500 crores. It would also be advisable to seek out the matching funds to the added to the corpus from the community of the NGO. Now, this corporation should be well versed in Muslim religious practice, those who administer and provision of Urdu. The corporation may continue provide financial and technical help for the development of the work properties with a view to enhance the work resources. Seminal cooperation should be established in all the states. This is the recommendation of the Central Committee report, and we don't know what is the further development by the central government in order to implement all these same recommendations that we don't know. It's in the darkness. Now, having said this, we have to go into the another crucial source of complaints which the government received touching the work board, mismanagement of work board. See, on 13th September 2024, the Ministry of Minority Affairs, it gives a press meet to the Press Information Bureau, a press document to the access of the general public. This document is nothing but FAQ. All that you know to need not to, you need to know about the proposed work amendment bill 2024 FAQ. This is uploaded in the Ministry of Minority Affairs and this is available in the net. That FAQ. That FAQ, the questions are there 6, 7, 8, and like that many questions are there. So for the public to access and know what is about all the work, the proposed work bill 2024 is. And here question number 6. Question number 6 is very crucial. This is for the public access to know about the work bill 2024. The work boards currently control 8.7 lakh properties, spanning 9.4 lakh acres across India, with an estimated value of 1.2 lakh crores. India is the largest Waqf holding in the world. Further, the Waqf board is the largest landowner in India after the armed forces and the Indian Railway. Someone asked me, what is this? The third largest landowner is the Waqf. It is true. Where is the authority sources? Where is coming? Even I have not seen any authoritative sources. But however, the Press Information Bureau, which is the FAQ, it mentions that Waqf is the third largest owner of the properties of the first. But however, the veracity, the authentic of the information that has been put is like that we see this is the academic interest. Someone can do that job. Now again, question number 14 is very crucial. This, in fact, this question number 14, when Honorable Minister Kiran Rijiju of the Minority Affairs Ministry, when he proposed the Waqf Amendment Bill 2024 in the Lok Sabha, he mentioned this question number 14 on the floor of the Lok Sabha itself. Such a significant incident happened in Tamil Nadu. There is a village called namely Tiruchendurai village in Tamil Nadu, which is near Tiruchi. I will just read the exact paragraph of the FAQ of question number 14. The question number 14 is titled as what are the type of issues complaint prevalent in the existing system touching the Waqf boards and Waqf properties. Tiruchendurai village, Tamil Nadu. I will read. The farmer Rajagopal, name itself mentioned. To the point, the farmer Rajagopal from Tamil Nadu was unable to sell his agricultural land to repay a loan because the Waqf board claimed his entire village in Tiruchendurai as its property. This requirement for no objection certificate caused financial and emotional distress. The village was historically donated as a waqf by Nawab Anwaruddin Khan in 1956. To prevent illegal sales or encroachment, the Waqf board requested the registration department to assign a zero value to Waqf properties, a request currently stayed by the Ministry of Minority Affairs. Now see, there is the Waqf here. The Waqf board claims that Tiruchendurai village to an extent of 389.03 acres are notified Waqf. And Waqf board claims the Waqf property. Here a farmer raises an issue that when he goes to register department, he is being barred from registering his own property. To his shock and disappointment, it has been classified as Waqf and zero value has been entered in the revenue records. Therefore, he could not able to register. And the registrar is demanding this farmer to get a non-objection certificate from the revenue board, and therefore there is an impediment of registration. Therefore, this Ministry of Minority Affairs, it passed in, we don't know what it passed. It passed a circular, a notification, or any order to stay the instruction of the Waqf board from alienating the property to restraining the alienation of the property. Now, where does this Minority Affairs Ministry got the power and authority to pass such an order? We don't know. However, Section 51 of the Parent Act 1995, which I read before, any alienation of a property or of a notified or designated park is a void. Now you have lifted the impediment which was given by the State Waqf Board, and therefore sale transaction are permitted, alienation property of the work is permitted. This I don't know. This is the so-called leaders of the Muslim community or the ulamas in the State Waqf Board. They have to answer what is the issue is all about. But this is in black and white and it's available and access to the public. This is one case. And after this, question number 17 also is relevant. Here, The Ministry of Minority Affairs has mentioned something about the Sachar committee report in the question FAQ 17, which it states that all that the Sachar committee has observed, which is already the 10% revenue, 12,000 crore annum, everything it has mentioned. Now we will go to, having said this, these are the two reliable documents and incidents which the central government relied while proposing the amendment bill, Waqf Amendment Bill 2024 in the parliament. Now we'll go into the Act, Amendment Act 2025. We'll see some provisions. Some provisions are welcoming. It is not that all provisions are conflict with the interest of the religious minority of the minority group of the Muslims. But certain provisions are welcoming, certain provisions are very controversial, some provisions are direct conflict with the scheme of the constitution. Only the court has to scrutinize that. Okay, it's what separately each provision. And now we'll finish in 30 minutes. The title of the Waqf Act 1995. The title of the Waqf Act Parent Act is just this only. Waqf Act 1995. Parent Act title. It is hardly 4 letters. WAQF. This Amendment Act 2025 has inserted 50 letters. See what it says that. The title of the act is Unified Waqf Management, Empowerment, Efficiency and Development. It is a radical departure from the doctrine of Islamic Waqf itself. And then we'll go to the other the digitalization of the work properties that is already there when the UPA government has introduced a WAMSI portal, that is the National Assets Management System portal is already in existence, but this is not new. But however, the controversial provision is section 3 capital B1 of the 25 Act. Hereafter, I will use 25 Act because I can't say the entire title of that. 25 Act says that section 3 capital B is it just gives 6 months for the complete digitization. 6 months, how 6 months is 6 months is not adequate for digitize all the properties of the work across the country. And now the claiming of the third work property, the third property in across the countries belongs to the work is something is not proven by any authoritative resources because the total area of the Hindu religious institutions in cumulatively in Tamil Nadu, Andhra Pradesh and Telangana, which comes to 10 lakh 37 and 358 acres. In just 3 states, the Hindu endowments property, their acres cumulatively expands to more than 10 lakh 37,358 acres. That exclusively or only the 3 states. If you take account of the across all the states across the country, all the Hindu religious endowments state, then something is matter of concern. Then there is a positive feature on this act that section 3 capital A. Section 3 capital A is inserted in the Parent Act of 1995. That is, it says that only the lawful owner can create a work. Yes, absolutely. A founder of the work environment, he should have a clear title, right, and interest in possession over the property. That is a welcoming provision. And so there is another section 3 or subclause 4 and subclause 6 says that uh, out of the work endowment, the widows, the divorced women and the orphans, they should also be taken care of from the benefits of the work environment. This is already implied under the doctrine of work itself. It is for only the religious, charitable and pious uses. There is no need to insert a separate section to extend the already existing benefit to the divorced women and the widow and the orphans. And section 23 is a welcoming provision of the Amendment Act 2025 is section 23. It improves the rank of the officer, that is the chief executive officer. Earlier he was to the level of the rank of the deputy secretary. Now this proposed that now the Act 2025 stipulates that he should be the officer at the rank of the Joint Secretary. So the CEO is an officer of the Joint Secretary means he's have a wide experience because he's a senior bureaucrat who has handled so many issues in this bureaucracy. So therefore, it is a welcoming provision. So one can expect an efficient and most effective administration and management of the properties by appointing a bureaucrat to the level of joint secretary as CEO. That's a welcoming provision. Then Section 83 of the Act 2025, it provides instead of there was a chairman who was a civil judge who was heading the work tribunal. Now he has been replaced by a district judge. District judge is the senior most judge of hierarchy among the state and who is having a well experience in different branches of the law. And being a district judge as a judge of a tribunal, something efficient disposal of the case can be expected. And always a district judge is more importantly, he is a designate of the he is a designate of a proposal of a high court elevation also. Therefore, this is a welcoming provision under 83 by the Act 2025. Now, 84 mandates the disposal, the time stipulated under the disposal is 6 months. So once the litigation is pending before the tribunal, it should not be continued or extended for time immemorial. There is a particular stipulated period given by the Act, that is Section 94. The tribunal has to dispose. That is what it has to pronounce an order within 6 months. That is also welcoming. And Section 64, it talks about the removal of Mutawalli. That is a Mutawalli who fails to maintain accounts for preceding 1 year without any reasonable cause. Then removal of Mutawalli is mentioned in section 64. Having said this, now we will go into the nuances of the 2025 Act. Yes, that is now 1954 and 1995. It permitted only Muslims to create waqf. Now, what has happened is the 1994 Act and 1995 Act, only Muslims can donate the property as a waqf record. This was the case. To understand this particular restriction, only Muslims can vote the waqf. What has happened is in the 1954, a mistake has happened. The 1954, under the definition of waqf, while they were drafting the definition of waqf during the 1954 Act, they copy and pasted the definition of waqf under section 1913 Musliman Act. What was the definition of the waqf under 1913 Act was copied under 1954, which excludes a non-Muslims from donating the waqf, and it confines only to the Muslims donating the property to the waqf endowment. And this particular insertion, even though was made in the Act 1954, however, the state of Tamil Nadu did not concede with that definition. State of Tamil Nadu was not satisfied with this particular definition, and it came with an amendment act, Tamil Nadu Waqf Supplementary Act 1961, very crucial. 1961, Tamil Nadu Waqf Supplementary Act 1961. The object of the act reads as follows: an act for extending the operation of the Waqf Act 1954 to any waqf created by a person professing any religion other than Islam. And the definition part, the term waqf, very crucial. It is defined in clause 1, subclause 1 of section 3 of the Parent Act 1954. Herein after waqf inferred to as the said act shall include all property given or endowed by any person professing any religion other than Islam for the support of three categories. Tamil Nadu Act, Supplementary Act 1961 gives three categories also to be construed as a waqf given donated by the non-Muslim. Number one, mosques, Eidgahs, Dargahs, Kankas and Maqbaras. Number two, graveyards of persons professing Islam. Number three, the chowdhuries and musparkhanas and for the benefit of person professing Islam. In all these three categories of the properties, even though it has been donated by the non-Muslim, it should be construed as per the definition of 1961 Supplementary Tamil Nadu Act as properties like this. So therefore, since however some progress has happened after this in the year 2013 amendment. This 2030 amendment is very crucial because this amendment gave some powers, it conferred some more powers to the state boards. And in one of the things which the 2013 did is it removed this unjustified restriction that even your property which has been donated by a non-Muslim as a work is deemed to be work property. And that was the thing was done in 2013. But this corresponding a controversial section is 104 that I will read the 104. You can find section 104 an enabling proviso. Section 104 is the enabling proviso under the Parent Act 1995. What it says, only I say the application. 104 1995 Act. Application of the Act to properties given or donated by person not professing Islam for support of certain wealth, notwithstanding anything contained in this Act, where any movable or removable property has been given or donated by any person not professing Islam for the support of a work, being the mosque, Eidgah, and all this thing, Kanka, everything come, then such a property shall be deemed to be comprised in the Waqf and be dealt in the same manner of the Waqf in which it was so comprised. This is the enabling provision under section 104 of the Parent Act 1995, but unfortunately, this section 104 has been omitted by the Amendment Act 1925. Now, where is the this thing now? One of the interesting historical facts to understand the non-Muslims who had donated their own immovable properties in vast extent to the betterment of the Muslim community, or one is there is a text, the 17th century text, Fatwa al-Alamgiri. Fatwa al-Alamgiri is a treatise on Islamic jurisprudence which was compiled during the reign of the great emperor Aurangzeb at the point of time. And the Fatwa al-Alamgiri was composed and it was the work of more than 40 ulamas who is proficient in Islamic jurisprudence. In the Fatwa al-Alamgiri, it is mentioned that there is no any bar for a non-Muslim to make a waqf government. And there is some judgment is also there. Okay, anyway, the relevance of academic interest, I will say in Pirota Peda Venkata Subrayadu versus Haji Silar Sahab. That is Pirato Peda Venkata Subrayadu versus Haji Silar Sahab, 1930. The Madras High Court has said it is for common for Hindu zamindars to make Muslim endowments, and it is the historical practices that the non-Muslim or the Hindus they used to donate their vast properties for the benefit of the Waqf. And another one incident I will share that there are two incidents where the non-Muslims have donated and taken part of the Muslim Waqf properties. One is the Nagur Dargah. See, 200 acres of land have been donated as a waqf to Nagu Dargah by the brother of the Krishna Devaraya. The brother of the king Krishna Devaraya, his name is Achyuta Devaraya. Achyuta Devaraya donated 200 acres of land to the Nagu Dargah. The historical fact goes like this. Achyuta Devaraya was suffering from severe stomach pain. He consulted various people, but he could not be able to get any cure. And somehow he came across Aulia Shaul Hamid, and this Sufi Aulia, he, after diagnosing the Achyuta Devaraya, he gave some treatment, some mystical treatment. We don't know what that has happened at that particular point of time, and consequently, his ailment was cured. In sense of gratitude of this saint Sufi Shalamir, Achyuta Devaraya, he donated 200 acres of land with Nagudala. There is a precedent, historical fact is there. Another one, very interesting. This is Lord Warren Hastings. Lord Warren Hastings was the first governor of Bengal at the year 1780. Now there is a Calcutta Alia Madarsa University. Calcutta Alia Madarsa University is the university was founded by Lord Warren Hastings. Not only this, he donated, he funded, and for more than 1.5 years, he maintained and he provided the salaries for the stars who are working in that university, and the Maulavis and the Mullahs and so-called preachers of Islamic studies, the remuneration salary was taken care of by the Lord Warren Hastings. And today it is that at that time it was Calcutta Madrasa, now it is Calcutta Alia University, and this is all. And these were the historical incidents where the non-Muslims, the Hindus, the kings, the Zamindars were donating the extent vast properties to the Waqf. And now we'll come to the crucial part of this provision is section 9 and 14. See, section 9 and 14 of the Act 2025, section 9, it says to include not more than 2 women. So, women representation according to Act 2025, it says not more than 2 women to be appointed in the Central Work Council and State Work Board, whereas the Sachar Committee recommendations and the earlier Act 1995 Act stipulates at least 2 women. Here the threshold differs. It says at least 2 women may be nominated in the Central Work Council and the State Work Board. However, this Act 2025 goes backward of women empowerment. It constrains only the maximum upper limit for 2 women. And of course, it also, the Act stipulates, 2025 Act stipulates inclusion of 2 non-Muslims as a member in the Central Work Council as well as the State Work Board, which creates the furor here. Now, 2 non-Muslims to be incorporated in the State Work Board is a welcoming to the context that, because since they are coming from different backgrounds, some divergent views will be there, some proactive way of thought process that will be benefit in the process of decision making. All those plus points are there, but the nomenclature, the composition of the Waqf and the Waqf board and the administrating of the Waqf endowment is covered under Article 26. It is Waqf administration is a religious denomination. Under Article 26, it is a religious denomination. It is completely covered under the guaranteed fundamental rights. There is a difference here. Article 26, even though stipulates general restrictions, that is subject to public health, order, morality, AO, but the rest of the general restrictions, it is guaranteed fundamental rights that any religious denomination is have a complete constitutional independent autonomy to administer and to manage its institution endowments and includes the Waqf for Muslims in that context. Now, if you say, if you give an exclusive independent fundamental right to the Muslims to govern and administer and manage their religious denomination, and how come these 2 non-Muslims will fit into the constitutional? You are just interfering into the guaranteed fundamental right. Just tinkering the fundamental rights which has been given to the Muslims to administer the administration. Therefore, this particular inclusion of two non-Muslims into the state Waqf board and also the central Waqf council has to test the judicial scrutiny because it is patently contravening Article 26 subclause B. See, if this inclusion of non-Hindus, non-Muslims to the state Waqf board is not similar to other existing religious endowments of Hindus. Now, here you can't export the Article 20. For example, you take Article 25. Article 25 defines who is a Hindu. Under Article 25, Hindu includes a Sikh, Jain, Buddhist, and so on. Whether yes, Parsi or whether a Jain, he can be accommodated in the endowment, a religious endowment run by the Sikh Gurdwara and in the panel of the board. Certainly not. Even though a Jain who has been classified as a Hindu under Article 25, except by a proper notification or an amending rules of the particular court, and even though he is entitled as a Hindu and got a right under 25, he will not be entertained by the Sikh Gurdwara board as a member. There is a clear cut constitutional demarcation of the boundaries of where a person can be allowed where he is not belong to a religious denomination. So this is the case under Article 25 for Hindus itself. A Hindu, by claiming a Hindu, he is not entitled to become a member. Whereas the question of coming a non-Muslim who is coming as a two members in the state board or in the central council. More importantly, so this is subject the court has to scrutinize on this line. And having said this, now the Act 2025 there is a conflict. One is in one proviso, Act 2025 says two non-Muslims has to be included. Another proviso, it precludes a non-Muslim cannot donate a property to Allah. See the yardstick. There is a, it is absurd actually. It is illogical, irrational. Here you say you allow non-Muslims to take participate in the management and administration of the Waqf property. And here you say no, they are precluded and the excluded. They should not even contribute any one set of land to the Waqf endowment. Something which is contrary and defies logic and reasoning according to well-established legal principles. Now we'll go to the Survey Commissioner. This is one of the controversial act. That is, the Survey Commissioner has been abolished. Survey in Parent Act 1995, what the Survey Commissioner do is he goes and along with Assistant Survey Commissioner to verify a particular properties of work for. Therefore, he goes and sees the property, he collects all the details, revenue records, the Waqfia, the Waqfnama, and the history of the founder, and what is in the articles of the Waqfnama, and what is the extent of the property, whether the revenue records are intact. All these field exercise will be done by the survey commissioner along with this assistant commissioner, and therefore he submits a report to the state government proposing that this is a work property. This is to be classified as a work property. But now this Amendment Act 2035 has removed the survey commissioner, abolished the survey commissioner. Now the powers are vested with the district collector. Now the district collector has to do this elaborate exercise. In fact, I would say that in administrative exercise and go to the respective field. Now the collector is already burdened with lot of administrative work. And also he functions as a quasi judicial authority for several appeals of which are emanating from different statutes. Where is the time for the district collector to go and do all this research of which property is to be classified as a work, which doesn't classify? See, this is an expertise field where the experts of the service commissioner and they have the record of experience and expertise and they know the know-how and know-how knowledge to how to classify all these, go through the revenue records. But this is something, this is going to burden the district collector in in a large amplitude. Now here comes the decision now. See, this is regarding the encroachment. This is a controversial provision. Decision when a complaint is given touching an encroachment of a work, where the government is encroached. Where here the encroacher is alleged government. The earlier section was section 40. Section 40, this particular proviso, section 40 of the Parent Act 1995 was the most contested, most forwarded, most deliberated, view the protest and across the social media news channels is section 40. That is really section 40, the enabling proviso, it empowered the state board. The state board of the opinion that a particular property is a waqf, according to its opinion, then it can declare, can pass an order to the effect it is deemed to be a property. So they said that it's an unbridled power as conferred upon the state board under section 40 to classify or to designate any property as a waqf if it is the opinion of the board that certain parameters this property has been qualified. To override this sweeping power of section 40 of the Parent Act 1995, they have deleted this particular proviso and conferred the power on the district collector to designate a particular, come to a conclusion to designate a particular property. Now see, this is dangerous proposition. See now what happens here, the respondent is the government itself. Who is the adjudicating body? The power is now given to the collector. Who is the collector? He is the government agency. How a government agency will give a judgment against its own? It is squarely against the patently, and I would say ex facie or prima facie, it is against the principle of no one can become a judge for his own cause. The district collector, he cannot pass an award, he cannot pass an order which is very neutral, which is not biased, because this is a title issue. That means what? Adversarial. Adversarial means what? Principle of natural justice, non-bias, non-mala fide, everything has to be followed. Here, man, you are putting a sitting and he is a government agent, and you want, how you expect justice? So this is the Act 2025 in order to curtail section 40, which is a malady according to the opinion of the government, section 40. Now it give the power to the, as a remedial measure to the collector, which is more than worse, and it is suggested by the legal experts and the ulamas that it may be given to a court or a quasi-judicial authority to decide the dispute about this particular aspect and not to the district collector. Now then it comes to the tribunal, the finality tribunal. Now there is under Parent Act 1995, the tribunal, whatever the order passed by the tribunal is final. Whatever the orders passed by the tribunal will be final according to the Parent Act 1995. But now this has been abolished. Now the High Court has been conferred as an appellate court, and now those who have been aggrieved by the order of the tribunal, they can go and approach, they can invoke the writ jurisdiction or any available remedy before the High Court. But anyway, when we compare to the finality of the tribunal order under existing 1995 Parent Act, when compared to the similar laws, similar religious endowment laws, with regard to their respective tribunals, they have maintained the status quo of the finality. For example, the Andhra Pradesh, the Hindu Endowment Tribunal in Telangana and Andhra Pradesh under section 85 subclause 3 is final. So the Hindu Religious Endowment Tribunal, as per the Andhra Pradesh and Telangana, in their respective state legislation, Hence, their tribunal, their religious endowed tribunal passes an order. According to section 85 subclause 3, it's deemed to be as final. Similarly, the HRNC Act, the 1959, the Tamil Nadu HRNC Act, the 1959, it confers the power to the Joint Commission. See, in the Joint Commissioner of the Endowment under section 79, capital A, subclause 3. HRNC Act under section 79, subclause capital A, subclause 3, it confers the Joint Commissioner to pass an order. When he passed the order, then that was final. Nothing has been touched upon on these two prevailing similar Religious Endorsements Act on the respective state. And this is, and we'll come to those. Another important provision here is section 108A capital A. What is section 108A capital A? 108A capital A is nothing but an overriding effect is given to the Waqf Act 1995. That means what? The Waqf Act 1995 provisions, which deals with the Waqf properties management administration, that it will not subject to any other existing legislation of Transfer of Property Act or Registration Act. So no other statutory legislation which comes conflict with the object and scope of those particulars under the 1993 Act. Absolutely the administration and management of the work properties. When these legislations are comes into the conflict, then the Waqf Act 1995 is a special law which has a overriding effect under section 108A that will not support this Amendment Act 2025, this 108A capital 108 capital A has been omitted, been deleted. That means what? Even any proviso which is conflicting to the interest of those those provisions of the Act 1995 that will prevail of that what is said in that particular legislation. For example, a Transfer Property Act or in Registration Act, whatever the provisions they say that these properties has to be subject to their provision. Then the Waqf Act 1995 has to follow it. So this is what taking of the overriding effect. But similarly, all these religious endorsements, this Andhra Pradesh religious endorsement, Hindu religious endorsements, the Tamil Nadu HRC Act, they have retained this overriding effect. They are rating significantly, they have retained this overriding effect. And for example, this the relevant provision, and then we come to that one another important controversy, which a provision section 107. After section 40, section 107 is very detrimental. Section 107 of the Parent Act 1995 excludes Limitation Act 1963 from the operation of the 1995. This means what? For example, the Waqf Board. Some knowledge, some information comes to the Waqf Board that certain property has been encroached for several years. And the Waqf Board was not affected. Information comes. Now, it is very well within the powers and ambit of the Waqf Board can file a suit for declaration that the particular alienation or a particular possession is null and void. This was the state before the Amendment Act 2025 under the Parent Act 1995 section 107 excluding the Limitation Act 1963. Another doctrine of that means doctrine of adverse possession is excluded. See, the Waqf Board goes and it claims that no, for several years you are staying here. It is a Waqf property. You go, then the person has to move out. He doesn't have any legal standing as per the 1995 Act. Now, what happens is inserting the Limitation Act and enabling the Limitation Act 1960 to the Waqf properties, the particular encroacher will take the ground of adverse possession. He will claim possession title on the basis of adverse possession because Limitation Act 1963 enables the doctrine of adverse possession. That is what? Uninterrupted possession for the span of 12 years. If an individual he is in the possession of a property without any intervention of the owner of the property, without any nuisance, and he lived for 12 years continuous in the possession, constructive possession, or maybe symbolic possession, then he will take the ground that he derives the title adverse to the owner's title. This comes under the gamut of the Limitation Act 1963, one of the feature of the Limitation Act 1963. Now, Section 107 has been incorporated that Limitation Act 1963 will apply to the work property also from the commencement of the Act. From the commencement of the Act 2025. But however, this is contrary because Sachar committee recommended the limitation period should be extended till 2035. He said that you don't bring any limitation act to the work property, let you extend the limitation act till 2035. Then let us see what's happened. But here this Act 2025 not bited. It brought the Limitation Act 1960 into the operation of the work property. This is one of the most detrimental provision. And in the similar endowments, strikingly more interestingly, the similar religious endowments, the Tamil Nadu HRNC Act and the State of Andhra Pradesh Hindu Endowments Act, Telangana, where section 143 of the Telangana Act and 109 of Tamil Nadu Act, respectively, they retain the exclusion of Limitation Act in their own religious endowment. That means a Hindu temple, they can claim the possession of the property at any time, no problem for them. If it has been encroached, if it has been encroached by any third party, there is no any impediment for the Andhra Pradesh Hindu religious endowment or the Tamil Nadu HRNCE under the respective provision to file a suit for recovery of possession. This is the similar legislation in the state. Now another thing is which has to be considered as now since Waqf property where it comes in the constitutional scheme there are union list, state list, concurrent list. Where do you see the Waqf property? Waqf property are subject to which legislative domain? Waqf properties are fall under concurrent list. That is concurrent list 3, 7th schedule, entry 10 and 28. If you see the entry 10 and 28, entries 10 and 28 of the concurrent list of the 7th schedule, you will find 10 is trust and trustees. Those properties vested with trust and trustees is entry 10, concurrent list. 28 is directly you can see the religious endowment and charitable purpose institutions. Once you say concurrent list, then lawmaking power based is the both the central government and the state government. But here in this Act 2025, even though the work properties are in the concurrent list, the central government is a proviso that it does not allow for the state government to make rules in some most controversial provisions under the Act 2025. This is another. Yes. So we'll come to a conclusion. Before ending, one particular aspect I have to share is rigorous impressment. Section 52A of the Amendment Act 2025 is under controversy. That is, before 52A of the Parent Act, the encroacher will be punished the rigorous imprisonment of 2 years. That was in the Principal Act. For encroacher, punishment is imposed for 2 years. But in the 2025 Amendment Act, it has been the word rigorous imprisonment has been substituted by the word imprisonment. This is the one controversial provision which has reduced the imprisonment and will almost these are the most controversial provisions which has to be almost the Supreme Court with these SLPs challenging all these controversial provisions and some provisions are welcoming under this act. And before concluding, I want to refer the Sachar committee observations, very crucial, and I will read that. and I conclude my lecture. That is, yes, this is found in page 2, same chapter, this page 2, Sachar committee report, chapter 1. Chapter 1, the title is Context, Approach and Methodology. Chapter 1 at page number 2, the committee mentioned Muslims, the largest minority community in the country, constituting 13.4% of the population. At the relevant point of time, 2006, constituting 13.4% of the population, are seriously lagging behind in terms of most of the human development indicators. So 13.4% at the relevant point of time, they are seriously lagging behind all the parameters of human development index. That means there is a serious concern that the proper administration and management is to be used for the benefit of the Muslim community in order to elevate and to remove from the most backward social, economic, educational conditions of the Muslims living across the India. And only one point which I have not discussed, that is the most controversial, the proposed amendment, the Amendment Act 2035 ignores is the Waqf by user. The Waqf by user is a doctrine which I already explained what is Waqf by user. But it says that the Waqf by user, those Waqf by user properties, those Waqf endowments, which are have been registered before or the commencement of the Act 2035, they are protected. However, the new registration of the work by user is not possible under the new Amendment Act 2035. This is against the well settled judicial precedent and proposition already has been settled for several centuries. The doctrine of work by user is intact and it is still continuing. And to plus to added advantage, there's the landmark judgment, the Babri Masjid judgment, that is Siddiqui versus Mahan Suresh Das, they recorded in 2020, Volume 1, Supreme Court cases, that in at page number 695, the Supreme Court has acknowledged the doctrine of work by user. This is one of the most important facet of work jurisprudence, and it continues and it still is really valid. However, the 2025 Amendment Act has not recognized work by user as a work endowment prospectively. But however, it recognizes retrospective, that is, those work by user registered are covered and not the future registered or proposed to register work by user. With this, I conclude my lecture. I extend my thankful gratitude to the entire team who have organized this wonderful lecture, and I immensely am satisfied. And I hope that the, the Muslim community, in particular, the leaders of the Muslim community, the Islamic organization, the ulamas, the jurists, the advocates, the time has come to rise for the occasion in order to take in the interest of the long future of the administration and the management of the work in the interest of the Muslim community across the country. Thank you. I can surround. Who wants to donate a property as a work endowment under the 1995, the 2025 Amendment Act, after the commencement of 2025 Amendment Act, he should be a practicing Muslim for preceding 5 years. Then only he can donate a property as a waqf. See, this first of all, this provision is goes against the the property rights guaranteed for the converts of Islam, new Muslims. These new Muslims only, they only for them these 5 years will apply, not for the Muslims who are by generation, because their father is a Muslim. Where is the question of for them to wait for 5 years? Because for generation by generation they are Muslim. This particular controversial provision is applicable only to the new converts of Islam. If they want to donate some property, as a Waqf endowment, they have to ask for the provisions of that. They have to wait for 5 years. And not only that, they have to prove that they were practicing Muslim for the preceding 5 years. The rationality. What is the rationality of this particular this thing? This provision of a new Muslim has to wait the 5 years. One important thing I also share this touching this. So, what is now, since having said that the proviso that one has to wait for 5 years and he has to prove that he is the practicing Muslim for 5 years, one interview, one program which was telecasted in the news channel Times Now, which was uploaded on April 2nd, April 2025. The chief editor of the Times Now, Navika Kumar, she has titled that particular program as Decoding Amendment Act 20 Waqf Amendment Act 2025 with the Tuklak magazine editor, Mr. Gurumurthy. He participated in that particular interaction where she raises this pertinent question to Mr. Gurumurthy that the new provision of the Amendment Act 2025 says that a Muslim has to practice 5 years before preceding donation the property to the Waqf, and who has to she asked very same this thing that who has to determine that whether a Muslim is a true Muslim, whether the BJP or whether the central government uh, or whether any court of law. Mr. Gurumurthy's reply for this is, I reproduce his exact word. He answers to the editor-in-chief Navika Kumar for this pertinent question. Once you state an appropriate fact in law, whether that fact is correct or not will be decided by the judiciary. This is what Mr. Gurumurthy replied to her. Now, we may presume or we may expect the central government to notify the constitution of a designated tribunals or courts to determine who is a true Muslim when he is intent to donate a Waqf property. Otherwise, how these criteria they are going to determine, it is not known. Therefore, this provision is very problem. This is what I want to add in my lecture.
So this will wrap up this session. Okay, so firstly, on behalf of Fraternity Movement Chennai, I'd like to extend my heartfelt gratitude and thanks to Saifullah sir. He immediately accepted our invitation when we contacted him, and he spent the last 2 to 3 weeks extensively researching. We actually wanted to conduct this event soon after, like when the issue was going on in the parliament. We wanted to be like an immediate thing. At that time, it was still a bill, not yet an act. But once he started researching, he said, I want to like clearly, fully go through everything and carry out a very extensive research. So he spent a lot of his time to do that, and we can see from his notes so many papers highlighting and everything. So thank you.